Hi, I'm Jim Covington. Today is January 21st, 2015. I'd like to welcome you to this week's issue of ISBA Statehouse Review. The new 99th General Assembly was just sworn in a week ago today, and they've begun introducing bills for starting committee action the last week of January and probably more accurately the first week of February. And I'd like to talk to you about 5 or 6 of those bills. Please note that 2 weeks from today, the Governor Rauner, will give his State of the State, and then 4 weeks from today, he'll give his budget address, so that will be also of something to watch. The first bill I'd like to talk to you about is Senate Bill 23, introduced by Senate President John Cullerton. The amends the Attorney Act to, under the current Attorney Act, you have to be a citizen to be able to petition for admission to practice law in this state. This deletes that. The Supreme Court is still in charge of licensing, and it requires 3 conditions for a non-citizen to petition for the admission of a license. And the United States Department of Homeland Security has approved the person's request for deferred action for childhood arrivals. The person's deferred action for childhood arrivals has not expired or been properly renewed, and the person has a current and valid employment authorization document issued by the United States Citizenship and Immigration Service. That's been introduced and referred to the Committee on Assignments for a later referral to a substantive committee. The second bill is Senate Bill 59, introduced by Senator John Mulrow from Chicago. Last year, the General Assembly enacted 2 changes to the Jury Act. One, we went from 12 to 6-person juries in civil cases only, and then it increased the fees from the $4, $5, and $10 a day and transportation expenses. This bill repeals the fee increase if the county board passes an ordinance that they simply can't afford it, and that they're going to be required to pay no less than the old law of $4, $5, or $10 a day and mileage, and that $4, $5, $6 is depending on the size or class of the county. And that's just been introduced and assigned to the Senate Committee on Assignments. The third bill is Senate Bill 45, introduced by Senator Jason Barrickman of Bloomington, and it is a Uniform Law Commission proposal, and it's called the Uniform Interstate Depositions Discovery Act, to allow, where there's pending litigation in another state, to create a simple administrative procedure to register that here, a ministerial, so that they can issue the subpoena to under Illinois Supreme Court rules governing subpoenas, so they can take a deposition in the state without going through opening up an entire new legal process. This is a 2007 Uniform Law Commission proposal that has gained widespread acceptance to make it easier for deponents in out of states. And I think there are 33 states that have already adopted it since it's been introduced in 2007. That's been introduced and sent to the Committee on Assignments. The next bill is House Bill 175, introduced by Representative David McSweeney from Cary, and it amends the Open Meetings Act, and it provides for a request for review may be filed no later than 60 days after discovery of an alleged violation of the Act, instead of the current law of 60 days after the alleged violation, if the facts concerning the violation are not discovered within 60 days after the alleged violation, but are discovered at a later date by a person using reasonable diligence. That's been introduced and sent to the House Rules Committee. The 2 final bills amend the Code of Civil Procedure. The first one is House Bill 96, introduced by Representative Andre Thapetti from Chicago. It amends the Respondents in Discovery statute to make 2 changes to that statute. One, it adds language providing that discovery may include a request for admission of facts or of genuineness of documents. And the second change, under current law, you can convert a respondent in discovery to a real defendant if the evidence discloses the existence of probable cause for such action. That is going to be changed to if a preponderance of the evidence discloses cause for such action. That's been introduced and is assigned to the House Rules Committee. The final bill I'd like to talk about is House Bill 95, also introduced by Representative Andre Thapetti from Chicago. It amends Section 1003 of the Code of Civil Procedure, which governs discovery and depositions, and it deletes the subsections B, C, D, and E, and simply says that references Supreme Court rules shall govern the subject matter of these repealed subsections. That's been introduced and assigned to House Rules Committee. Thank you for tuning in, and we will see you next week.